Exam Scholar, Real Estate Edition.
Question 1. A buyer of a residence, prior to the close of escrow, asks the broker for permission to move into the property. The broker should A. Deny the buyer permission. B. Grant the buyer oral permission. C. Ask the buyer to sign a lease for the property. D. Obtain written consent from the owner. Answer. D. Prior to the close of escrow, the seller is still the owner, therefore, the broker should get written consent from the owner before allowing a buyer to take possession. Question 2. An alienation clause provides that A. The principal amount of the loan, plus accrued interest, is due in the event of the sale of the property. B. The mortgage is security for a promissory note. C. A lien can be placed on the property that takes precedence over a prior recorded trust deed. D. None of the above. Answer. A. Also called due on sale. It states that the lender may demand the loan plus accrued interest be paid in full in the event the property is sold. Question 3. If a man has a freehold estate, which of the following would result in his having a less than freehold estate? A. Sale and leaseback. B. Selling the mineral rights to a third party. C. Giving a leasehold interest for 5 years. D. Granting a life estate. Answer. A. A less than freehold estate is a landlord/tenant arrangement. Of the choices offered, only a sale leaseback would result in a less than freehold estate. Question 4. Broker Young, as an agent, showed a property to James. James signed a deposit receipt which contained the following words: buyer to accept the property in an as-is condition. Broker Young knew that the plumbing in the property was in a major state of disrepair with parts missing, but he did not tell James. The problem with the plumbing would not be apparent to an ordinary, prudent person. If James sued the seller for damages for fraud, the court suit would probably be A. Unsuccessful because the as-is provision in the deposit receipt shows that there is a mutual understanding of possible defects. B. Unsuccessful because the deposit receipt specifically state buyer to accept the property in an as-is condition. C. Successful because the duty to disclose a material fact cannot be avoided by an as-is provision under the stated circumstances. D. Successful because as-is refers only to obvious defects. Answer. C. The real estate commissioner and the courts are very protective of consumers. Therefore, they will not allow an as-is clause to be valid except for obvious defects, which any reasonable and prudent person could discover. Question 5. To alienate title to real property, one would A. Encumber it. B. Place a homestead on the property. C. Convey the title. D. Cloud the title. Answer. C. The term alienate means to transfer or convey. To alienate title means to convey it. Question 6. Real property would include A. Real property tax lien. B. Trust deed. C. Crude oil which has just reached the surface in a pipe drilled beneath the land. D. None of the above are real property. Answer. D. None of the possible answers to this question is real property. A tax lien and a trust deed, although having to do with real property, are not real property. Oil which has been captured is personal property. Question 7. Which is true concerning an option? A. Title acquired by exercising an option usually dates back to the time of the option and cuts off intervening rights acquiring with knowledge of the existence of the option. B. Only the optioner is bound to a sale. C. The optionee has no interest or estate in the land. D. All of the above statements are true. Answer. D. All of these statements are true. Question 8. Abel buys Blackacre from Baker, taking title to the property subject to the existing loan. The person primarily responsible for the repayment of the loan would be A. Abel. B. Baker. C. Either Abel or Baker. D. Neither Abel or Baker. Answer. B. When a buyer takes title subject to the loan, the seller retains the responsibility for the repayment of the note. The buyer takes no responsibility for the note. The buyer can lose a property by foreclosure because a property was bought encumbered with loan, but after the foreclosure, if there is a deficiency in the process, the buyer is not liable for that note deficiency. Any suit would be against the seller for the deficiency judgment as the buyer's name does not appear on the note. Question 9. A lessee's interest is A. Personal property. B. A chattel reel. C. A grant to use property for a period of time which reverts to the grantor at the expiration of the term. D. All of the above. Answer. D. All three choices refer to the lessee's interest in real property. Always keep in mind that a lessee's interest is personal property known as chattel reel. Question 10. An apartment owner was figuring his net income for income tax purposes. He took the gross income and deducted certain expenses. Of the ones listed below, which could he not deduct? A. Depreciation. B. Interest on loan for purpose of purchasing the property. C. Management expenses. D. Cost of offense. Answer. D. Offense would be a capital improvement. The cost of it should be added to the cost basis of the property and depreciated. Question 1. In portfolio risk management, a lender considers A. Diversification. B. Liquidity. C. Reserves. D. All of the above. Answer. D. In portfolio risk management, a lender determines what type of loans to have in his portfolio. Factors are: how quickly can I sell these loans? What are my reserves? How diversified are these loans? Are they all business? Are they all residential? Are they a mixture of business and residential? Question 2. You sell a note with a face value of $12,000 for $10,000. You are A. Discounting the note. B. Amortizing the note. C. Committing an act requiring a real estate license. D. Committing fraud. Answer. A. Anytime you sign a note or sell a note and the amount you receive is less than the account stated on the face of the note, you are discounting the note. Question 3. An able buyer means one is A. Financially able. B. Having the ability to obtain the necessary funds to purchase real property. C. Having the ability to obtain necessary financing. D. Any of the above. Answer. D. Any of these would indicate an able buyer. Question 4. The right to foreclose a trust deed, under a trustee's power of sale, outlaws A. In 4 years. B. In 3 years. C. In 2 years. D. Never. Answer. D. A trust deed is not a contract, but rather a conveyance of the naked legal title with the power of sale from the trustor to the trustee. Therefore, the trustee retains the right to sell the property under the trust deed at any time for the benefit of the beneficiary. The conveyance has been performed and thus is not under the statute of limitations, therefore, it never outlaws. Question 5. Broker Styles took a listing from a seller using the standard listing form. 1 week before the listing expired, the broker informed the seller that he had a prospective buyer named Bennett. After the listing expired, the seller listed with broker Johnson. Johnson showed the property to Mr. Bennett and obtained an offer that was accepted. Under these circumstances, A. Broker Styles gets a 6% commission. B. Broker Johnson gets a 6% commission. C. Both brokers get a 6% commission. D. Broker Styles gets a 3% commission and Broker Johnson gets a 3% commission. Answer: B. In the safety clause of the standard listing form, Broker Styles would agree to relinquish his safety period if the property were listed with another broker. Question 6. A loan created with more than one borrower is usually added to the promissory note for the protection of the lender. A. Beneficially. B. Jointly and severally. C. Universally. D. Unconditionally. Answer: B. When there is more than one borrower on the note, the promise and obligation to pay that balance is the responsibility jointly of all the co-borrowers, and also each individual is severally liable for the full debt. Severally, in law, means individually. Question 7. Mr. and Mrs. Johnson, who had been shopping for a new home, found one that they liked very much, but because they felt the property was overpriced, they decided not to buy it. Their reason for not buying was probably based upon the principle of A. Conformity. B. Substitution. C. Highest and best of use. D. Anticipation. Answer: B. It must be assumed that our buyer has found another home that was equally desirable but at a much lower price. This is the idea behind the principle of substitution. Question 8. When a broker misrepresents his principal's property to a buyer, he could cause his principal to be subject to A. A court action for damages by the buyer. B. A rescission of the sale by the buyer. C. Civil responsibility for compensating the buyer for misrepresentation of the broker. D. Any of the above. Answer: D. The principal is responsible for his agent's actions. If misrepresentation occurs, there should be a rescission of the sale or civil court action for damages. Question 9. An owner of a 5-unit apartment building that is located within the city limits intends to convert the building into 5 condominium units and offer them for sale to the public. Under these circumstances, the developer A. must obtain a public report from the Real Estate Commissioner under the Subdivided Lands Act. B. must file a map with the city under the provisions of the Subdivided Map Act. C. is exempt from the Subdivided Lands Act and the Subdivision Map Act. D. must comply with the Subdivided Lands Act and the Subdivision Map Act. Answer: B. Any type of subdivision located within the city limits is exempt under the Subdivided Lands Act, but a condominium conversion of 5 units or more is covered under the Map Act and must be filed with the local authorities. Question 10. After acquired title is conveyed in any trust deed for the benefit of the beneficiary, it conveys A. personal property later affixed to the real property so as to become real property. B. improvement built on the land after title is acquired. C. additional land acquired afterward by the trustor. D. all of the above. Answer: D. After acquired title refers to title to fixtures or other real property items that become part of the land that is securing the existing trust deed. If a lot serving as security for a loan made 10 years ago has land affixed to it, that land becomes encumbered with the lien made 10 years ago. If additional improvements, such as a swimming pool, added bedroom, or new landscaping are added to the real property, they to become encumbered with a trust deed lien made 10 years ago. Question 1. Which of the following items is usually considered to be a cost of home ownership? A. Land depreciation. B. Improvement appreciation. C. Amenity value. D. Interest lost on the owner's equity. Answer: D. The interest that is lost on owner's equity is usually identified as lock-in equity. This term applies to the fact that the owner cannot utilize the funds for other investment purposes. Question 2. Abel submitted an offer to purchase Blackacre. During the escrow period, a local credit reporting agency submitted detrimental information which Abel contested. Abel made repeated attempts to get the matter corrected, and he was denied access to the information reported to the agency. Abel may A. Bring an action to recover punitive damages of no more than $5,000. B. Bring an action in a court of appropriate jurisdiction to recover actual damages. C. After a prescribed time, require the reporting agency to delete such information from the report. D. All of the above. Answer: D. All choices are open to the principal in question. Question 3. Mr. O'Reilly paid an owner $10 for an option containing this clause, option to be for 60 days from June 1, 1967. Upon exercise of option, holder is to purchase within 30 days thereafter for all cash consideration. On July 10, Mr. O'Reilly sold and assigned his option for $1,000. On July 28, the new holder notified the owner that he would purchase on August 15. The owner claimed the option was void. The option was A. Void, because the holder sold it. B. Void, because date of purchase was not within the option period. C. Valid, even though Mr. O'Reilly sold it, but August 15 was too late for date of sale. D. Valid, and a signee could purchase on August 15. Answer: D. Inasmuch as the terms of the option are for all cash consideration and no unsecured promissory note is involved, it must be sold or assigned, because the new holder exercised the option within the 60 days period, before July 30, and purchased the property with 30 days of the exercise date, before August 30, the option is valid. Question 4. Other than non-dischargeable debts of a bankrupt debtor are cut off, discharged. A. Publication of the notice of the petition in bankruptcy. B. Discharge in bankruptcy. C. The first meeting of creditors. D. Filing the petition in bankruptcy. Answer: B. Debts are cut off, discharged, the date bankruptcy court issues a discharge. Question 5. In which of the following ways may an agency relationship not be created? A. Verbal authority. B. Necessity or emergency. C. Post hoc ratification. D. Subordination. Answer: D. Subordination means lie, trickery, or deceit, hence, it cannot be a valid way to create an agency. Question 6. A person and his property that is encumbered by a first deed of trust are in Chapter 7 bankruptcy. The court can sell the property and use the proceeds therefrom to pay debts owed to unsecured creditors. B. Holder of the first deed can foreclose. C. Debtor need not make payment on the promissory note secured by the first deed of trust. D. Debtor can sell the property. Answer: A Chapter 7 bankruptcy petition creates an automatic stay of a creditor's foreclosure against the debtor. Creditor must file a petition with the bankruptcy court seeking relief from the automatic stay and approval to institute foreclosure action. If the note is oversecured by collateral, the bankruptcy court trustee may sell the property, pay the secured creditor, and use the excess proceeds to pay unsecured creditors. If the debtor does not make payments on the note during the automatic stay, the bankruptcy trustee will pay interest to the secured creditor from the date of petition to the date of sale. Question 7. A loan that is secured on easy terms and with a low down payment usually results in A. Increased financing costs. B. Decreased financing costs. C. No difference in financing costs. D. Faster amortization. Answer. A. The lender is not going to be given easy terms or long-term financing without securing something in return. This usually results in increased financing costs. Question 8. Insofar as a residential neighborhood is concerned, which of the following would offer the least protection against blighting influences on future development? A. Natural or artificial barriers. B. Partially built-up neighborhood. C. New neighborhood in the path of directional city growth. D. All families with similar income. Answer. B. A partially built-up neighborhood would have a definite tendency for blighting, because it was not completed and there would be a potential for vandalism. Question 9. In negotiating certain loans, a broker is required to fill in all of the items on a broker's loan statement form. The following item must be inserted. A. What the borrower intends to do with the proceeds of the loan, less expenses. B. A statement of the value of the property supported by a proper appraisal. C. The date on which the borrower acquired the property. D. The amount that will be charged by a qualified agency to render a report on the financial capacity of the borrower. Answer. D. The loan broker law requires, among other things, that the broker's loan statement contain estimated costs including appraisal, escrow, title, notary, recording and credit investigation. Question 10. Which of the following is not a characteristic of an easement? A. It is an interest which can be protected against interference by third persons.
B. S pause. Second equals 0.80 pause. It is capable of being created by a conveyance.
C. It is considered a non-possessory interest. D. It is an interest that can be terminated at will by the possessor of the land. Answer. D. The possessor of the land is the owner of the land. He cannot terminate the easement at will.
Exam Scholar, Real Estate Edition.